Hello, my name is Josh Blackman. I am the president of the Harlan Institute. I am joined by my colleague Julie Silverbrook of ConSource. And today we are hosting another round of the virtual Supreme Court competition. And the case is Zivotofsky versus Kerry. Arguing on behalf of the petitioners is going to be Zohar and Sarah. And then arguing on behalf of the respondents is going to be Emily and Evan. And both of these are from Oswego High School in Oregon. So first up, petitioners, whenever you're ready, you may proceed. And you have 20 minutes. I understand you're reserving 5 minutes for rebuttal time. Okay, so you have 15 minutes. Whenever you're ready.
In the case of Zivotofsky v. Kerry, it is the position of the petitioner that the president's recognition is subject to oversight and control by Congress. This position is based in textualist and originalist arguments, which would indicate that the founders never intended for one person alone to have control over such momentous decisions. The case delves into not only the recognition of governments and the borders in question, but also the overlap of congressional authority in matters of foreign diplomacy. Well, it would seem that Article 2, Section 3 of the Constitution gives the President the power of recognition through the acceptance of ambassadors. The verbiage of this clause would indicate that it is a duty of the President rather than a power. This interpretation is supported by multiple documents written by the framers. Furthermore, the clause in question is the only clause in the Constitution in which the executive carries out a diplomatic action without congressional approval or authority or intervention. This position is supported by the specifics of the case and the nature of recognition in question.
The most critical element of the petitioner's argument is the fact that such a momentous and weighty decision should never, and in fact was not, left to the judgment of the executive alone. Recognition is defined as the act by which a state commits itself to treat an entity as a state, or to treat a regime as the government of the state. The powers of the President, enumerated in the Constitution, are found in Article 2, with those relating to recognition found in Section 3. Article 2, Section 3 states that the President shall receive ambassadors and other public ministers. The most critical element of this section is the use of the word shall, as opposed to shall have the power. The verbiage of Article 2, Section 3 would seem to indicate that receiving ambassadors considered an integral part of the act of recognition is a duty or an obligation of the President rather than a power or a choice that he gets to make at his own discretion. This is supported by the verbiage of Article 2, Section 2, Clause 2. The President shall have power, by and with the advice and consent of the Senate, to make treaties, provide 2/3 of senators present shall concur, and he shall nominate, and by and with the advice and consent of the Senate, shall appoint ambassadors. So when he says it shall have the power to, he gets to make that choice. He gets to negotiate those treaties by his own discretion, as opposed to shall is more of a direction. That's something that he has to do.
A command.
Yes. When power is delegated to an entity in the Constitution is done so explicitly, and in the case of receiving delegates from other nations in an act of recognition, this is clearly not a power delegated to the President, but a ceremonial duty bestowed upon him to be fulfilled at the advice of another entity, which we will find is Congress.
So Counselor, if I may ask the first question, why should the Supreme Court be getting involved in a case of such momentous occasion? I mean, this involves the Middle East, which is a very radical and controversial place where our national security is at. Shouldn't the court simply defer to the executive on a matter of such gravity?
No. Well, I mean, it's a little late for that at this point, but...
Well, why is it a little bit late? I mean, we could simply rule in the President's favor. It's not too late. Or rule in the Secretary of State's favor.
That's true, but it is the position of the petitioner. It is the position of the petitioner that we should not do so. I mean, the second that the Supreme Court decides this isn't a matter that's within their jurisdiction to rule on, I mean, you kind of set down a slippery slope. You've basically given the President to decide that I'm taking this power and that I have the ability to do this. So what's next? What else can the President decide for themselves that they own that power?
Right, but what's the slippery slope, Counselor? This issue hasn't come up in nearly 200 years. It doesn't seem like it's been very controversial.
Well, I mean, you would say that it doesn't seem very controversial, but in the past 200 years, as we'll find, the President and Congress have usually been in concurrence. And the fact that it hasn't come up for the past 200 years isn't a reason to say that it's not a constitutional question. I mean, Marbury v. Madison didn't come up for 50 years, and now look what we have.
Counsel, let me ask you a follow-up question, right? So you mentioned that Congress and the President seem to be aligned in a lot of cases where the recognizing a certain sovereign authority over a certain territory. But can you think of a couple of examples, maybe from early American history, where there was disagreement between the executive and Congress?
Oh, when there was disagreement?
Mm-hmm.
No, not off the top of my head, no, and that's probably why it didn't come up for a very long time, because the President and Congress usually were in agreement about what path the United States would take. Or at least in early American history, we weren't that big of a player, so whether we recognized another nation or not wasn't that big of a deal.
Impact.
Okay.
So if I can ask a follow-up question as well, in your research, did you come across any examples of anything from the Washington administration, the very, very first president that may implicate our decision today?
Anything from Washington, President George Washington, who made any actions that would implicate the decision? No, we didn't come across any actions that President Washington did. Okay.
Okay, but what about setting aside, the activities of a particular administration? What did the individuals who framed and ratified the Constitution, did they say anything that should bear on the outcome of this dispute?
Yeah, glad you asked. We have several documents, mostly Blackstone's Commentaries and several Federalist Papers, as well as letters that different framers wrote to each other.
And let me ask a question before you start talking about that. Can you explain to me the legal significance of Blackstone's commentaries or the words and essays of the framers?
Well, the importance of the framers, we specifically cited Federalist 69, which was written by Alexander Hamilton. But the point of those documents, they were originally written as kind of in order to promote the United States government under the Constitution and like the Federalist government that they were trying to create. So obviously because one of our arguments is kind of an originalist argument, or if you like, and it's the intent of the framers.
The legal significance is that we have the text of the Constitution. The text of the Constitution is, we can fit it into many booklets now, and it doesn't cover everything that could have ever happened. So when we have questions which might not be explicitly stated in the Constitution, we need to look at what the founders' intent would have been, what they maybe would have wanted when they were drafting the Constitution.
Okay, thank you. Now you can go ahead and tell us what they did say. Thank you.
Well, we have multiple documents which would indicate the framers' intent. Firstly, in Federalist 69, Alexander Hamilton wrote that the President is also to be authorized to receive ambassadors and other public ministers. This, though it has been a rich theme of declamation, is more a matter of dignity than authority, which goes further with our verbiage argument. Congress, whenever power is delegated to Congress, it says in the Constitution, Congress shall have the power to, whereas the President is always, the President shall do something. He's directed to do something, whereas Congress is the proactive branch of the government. And again, Alexander Hamilton would back up that argument. He is directed to receive ambassadors rather than to do so at his own discretion. Further credence is given to the argument when entertaining the idea of national rebellion or other questions and circumstances, which starts to get more into this case of where our borders. According to St. George Tucker and Blackstone's Commentaries, their section of foreign ministers can involve questions of delicacy, especially in recognition of authorities of a doubtful nature. A scruple is said to have been entertained by the President of the United States as to the reception of the first ambassador from the French Republic, but it did not prevent or retard his reception. And the reception of an ambassador from the French Republic was also an act against the very...
So, Counsel, let me ask you a question. I asked you a couple minutes ago about any examples from the Washington administration. What is this discussion of French ambassadors? What time period did this occur from?
Well, this, I'm fairly certain, didn't occur during the Washington administration. This occurred during the French Rebellion, after the American Revolution, after Washington had already left power. I'm pretty sure that this was...
What's the year on the source that you're referencing?
Let me check on that. I'm not sure I have the year on that, the exact year on that.
Okay, I assume it's in your brief?
Maybe.
Okay, let's move on to another element of your argument. So you mentioned that the question of receiving ambassadors and recognizing a particular government actor as the representative of a particular sovereign authority could be an issue of delicacy. This seems to be a fairly delicate issue. Geopolitically, the conflict over the territory of Jerusalem is quite hot, quite volatile, right? This is a key part of the Israeli-Palestinian conflict. Isn't what Congress doing here really invading on the president's prerogative through his Secretary of State to negotiate these kinds of issues?
The president's prerogative to negotiate these, to intervene in other nations' foreign affairs. I mean,
yeah, tell me a little bit about the president's foreign affairs power. How does this not just fall as part of that?
Well, it doesn't, because the president is usually directed to do something by Congress. And if we look at that case of the French Republic, and when the French Republic was in rebellion, the president accepted the ambassador from the rebelling French Republic, despite any personal feelings that he may have had, because he was directed to do so, because that was what the rest of the nation seemed to do.
So are you arguing that the president is really just an instrument of Congress? And I mean, do you think that constitutional design and the facts of our history bear that out?
I think that it isn't necessarily an instrument, but it's more of it's a group effort, if you will, between the president and Congress to work in foreign affairs. I mean, if you look at almost any other foreign affairs the president could be connected to, making treaties have to be approved by the Senate. Declaring war.
But who makes the treaty? Who makes the treaty?
Here's the thing: the president makes the treaties, but they couldn't give 535 congressmen, put them all in a room and ask them all to start negotiating at once. You can't negotiate a treaty with 535 people.
But doesn't that seem to suggest that the president actually has a separate sphere of authority from Congress?
Well, it would seem to suggest that the president is meant to do certain things that would be impractical for Congress to do. And if you'll let me continue on, it would seem to indicate that Congress is the proactive branch and that the president is supposed to carry out Congress's proactive things. Congress is a legislative branch. They pass the laws, and then the executive branch executes those laws.
It's a reactive branch.
But I'm a little confused, because the president makes treaties by and with the advice and consent of the Senate. So that seems to suggest that the Senate is actually approving something that the president has proactively already done. I'm just trying to understand your conception of executive versus congressional power here.
Well, listen, the president, I guess, can go and contact whether foreign dignitaries he wants, and he can tell them, you know, I'm going to start negotiating this treaty.
But you suggested before that he can't do that. He can only do it if Congress authorizes him to do it.
The president can't do this with any legal way, because he can go and contact these foreign dignitaries, and he has to contact the heads of other governments. He has to do that on a regular basis. But he needs to get all of his treaties passed by the advice and consent of the Senate. And
what about all of the executive agreements that presidents have made for years and years that are not treaties but are seen as the authoritative actions of the federal government and are respected on the international stage? Are you saying those things carry no legal weight?
I'm not saying that they carry no legal weight. I'm saying that they're another ministerial duty of the president. They're things that you don't need 535 members of Congress to get together and approve.
Okay, we're going to move on from this, but I still do have some questions about the conception of presidential power that you've laid out here, so I may follow up on this, but I'm going to let you get to your next point.
Okay.
We were discussing, we just finished discussing the French Republic. Well, the president may not have personally relished the idea of receiving the ambassador who has fulfilled that duty without delay. This is explained by James Madison, who in Helvetius number 3 explains the reception of an ambassador is dependent upon two questions. The first are his credentials from the existing and acting government of his country, and two, are they properly authenticated? Normally, this is a straightforward matter, and in cases in which two governments simultaneously claim lands, however, the reception of ambassadors becomes more contentious. Specifically, the reception of an ambassador from one Specifically, the reception of an ambassador from one government could be seen as an act of aggression towards its rival. According to William Rawle, the president, who not having the constitutional power to declare war, ought to ever to abstain from a measure likely to produce it. In regards to questions of such delicate nature, the president is subordinate to the powers of Congress. While the powers of the president abstract are very limited, they become non-existent in the context of Mr. Zivotofsky's request, and the question whether congressionally enacted statute that directs the Secretary of State, upon request, to record the birthplace of an American citizen born in Jerusalem as born in Israel on a consular report of birth abroad and on a United States passport is unconstitutional on the ground and the statute that impermissibly infringes on the president's exercise of recognition. Most of the literature on recognition is based around the reception of ambassadors and the legitimacy of government.
Okay, Counselor, you have about 30 seconds left. I don't mean to interrupt, but you have about 30 seconds left with your time.
Okay.
Well, if we have 30 seconds left, lastly, I'd like to bring up the idea of the case of Youngstown Sheep Tubing Company, in which Justice Jackson wrote a concurrence which still carries much legal weight from many scholars and congressmen, in which the third part of that concurrence said that when the president is at odds with Congress and when they are not, when the president tries to take actions that Congress does not agree with, the president's power is at its most limited, and he has only the powers which are explicitly delegated to him by the Constitution, minus any of those which Congress has delegated to them in the Constitution. So if Congress has taken an action, according to Justice Jackson, which is within the Congress's abilities, delegated to them by the Constitution, and if it is at odds with the president's action, then Congress wins.
Okay, Counselors, thank you very much. Justice Silbrook, any other questions?
No, just remind you that you have 5 minutes for rebuttal.
Okay. So if the respondents, Emily and Evan, would be come up, you can begin whenever you're ready.
Despite the Supreme Court deeming this case judicially acceptable, the President continues to hold the power of deciding whether or not to recognize Jerusalem as part of Israel, on the grounds that both the founders, as well as the Constitution itself, have intended for the executive to hold the power of recognizing foreign nations alone. The President alone holds the power to recognize foreign states or governments, and thus whether the United States recognizes Jerusalem as being part of Israel is the executive's decision. For this reason, the Secretary of State is allowed to deny Zivotofsky the right to put the birthplace of Israel on his American passport. The official position of the Obama administration is that it is within the power of the President to decide whether to recognize Jerusalem as being part of Israel. The right to recognize foreign states or governments is found within the Constitution in Article 2, Section 3, which states that the President shall receive ambassadors and other public ministers. It is explicitly stated in the text the right of the President to deal with foreign affairs, having the ability to appoint ambassadors, make treaties, and receive ambassadors and other public ministers.
Counselor, can I ask you a question?
Yeah.
What foreign affairs authorities are delegated to Congress in the Constitution?
They have certain war powers. That's one example where we see that the Congress is actually more proactive and the executive is more reactive. They get to declare war. Also, treaties. The Senate gets to confirm treaties as well as ambassadors.
They also get to, they have some voice in when the president assigns delegates. They do get to give advice to the president in these matters.
So if foreign affairs isn't exclusively the president's realm, right? The Constitution gives both Congress and the executive foreign affairs authority. Why is the recognition power exclusive?
Recognition power is exclusive because, as we can see, the president needs to be able to have this authority. He's one man and he's one sole voice of the American people. Therefore, like, if we divided this power up into the 535 delegates of Congress, we would not have the one full authoritative voice. We've seen this in things such as, the Iran delegation or the Iran nuclear debates, in which the Congress sent a letter to the Iran delegation that basically prevented us from being able to enact foreign policy because they were going behind, a voice or an image that we were trying to portray because they were, divided in so many different ways.
And Thomas Jefferson has talked about the Senate's role in foreign affairs aligned with the president. He said that the executive was meant to hold recognition power when he describes his vision on the Senate's strict and limited roles in regards to diplomatic appointments, So even though there are some roles that the Senate and the Congress itself plays in foreign affairs, he talks about how they have to be explicitly stated. And anything that is not explicit directly goes to the executive.
Well, let me ask you this question. Why didn't the president just veto this piece of legislation? If he thinks this intrudes on his exclusive recognition power, veto it.
It seems to me that he is trying to go through the proper channels and say that, he's trying to make a declaration that the president does have this power, and he's trying to get the court's approval on this matter, because this is going to be a contested issue eventually, and we may run into this issue consistently.
But if his power is clear, why does he need court approval? Why not just assert this? Right? Congress passes this piece of legislation. He has to approve it. He says, no, Congress, you don't get to decide that people can list on their passport if they're born in Jerusalem, that they're actually born in Israel. That's my exclusive power to do that.
And obviously we are seeing that this isn't extremely clear because, like the petitioner said, it's implied. The recognition power is not explicitly stated. It is implied from Article 2, Section 3.
Right, but the question of whether or not it's implied or expressed is different than whether or not it's exclusive. So I'm talking about if he's saying this is an exclusive power, regardless of whether or not it's expressed or implied, right, why not just veto the legislation?
Because it's a question of his power, and if you were to use his power to assert his power, that would kind of be, it would be contradictory. It would say that, I am a dictator in some ways, which is not the case. He's trying to use the power that's delegated to him in the Constitution to show that he does have the power in this instance.
So is your argument that neither political branch of government, neither Congress nor the president, can assert constitutional power before first hearing from the court about whether or not it's appropriate for them to do so?
No, I'm saying that he's making a statement about the authority that Congress is challenging. He's saying that because they have challenged my authority, I'm going to go to another authority on this matter. And
but I'm saying, why does he have to? He could have just vetoed it. He could have just said, nice try, Congress. You don't have the authority to do that. I do. Veto.
Unfortunately, I'm not the executive, so I wouldn't be able to make a statement.
They can override the veto, obviously, with the two-thirds vote. And then also we have to remember that this is a very, very confusing situation. It's very complex. And in our speech, we talk about Joseph Story, who was a 1700s American jurist on the Supreme Court, and he did talk about how this is a complex situation, how this isn't just someone. This is something that we haven't really had in our history. Well, we talk about later in our speech, George Washington. He was the president during the French Republic's rebellion, and he did get to just say no. He did remain neutral. But George Tucker and Joseph Story talk about how there's complex situations, but in these complex situations, we still need to look to the executive.
So, Counselor, let me ask you a question. We've talked a lot about the history of the Constitution, but the simple fact is Congress does have this shared authority in many respects. For example, Congress has authority over the Foreign Commerce Clause, right? Why is this not an aspect of foreign commerce? Why is not the passport foreign commerce? Why is not a person seeking to travel abroad, which is what the passport's used for, foreign commerce? Why isn't this another instance where Congress does share their foreign power authority with the president in this respect?
I feel like this is an issue of image in terms of what the president's able to do, right? Could you restate the question?
This is a situation that is going to affect free countries. It's not just going to affect American people going to and from. It's going to affect Palestine, it's going to affect Israel, and it's going to affect the American people as well.
Counselor, let me ask you this, though. Is it really? Is Congress allowing the select number of people who are born in Jerusalem to elect, right? They're electing, if they're born in Jerusalem, to put on their passports that they're from Israel. Is this really a case in which Congress is actually recognizing Israel as the sovereign authority of Jerusalem?
Absolutely. Absolutely. And that is why the Supreme Court jurist, Stephen Breyer, said that this is a political question and that we shouldn't even be looking at this. Because in order to answer this question, we have to go dive deep into international affairs. And that is really, really tricky. It's politically tricky. And both Israel and Palestine are they're going to react. There's no question about it.
But with respect to my dear colleague Justice Breyer, whom I always agree with, do we really have to do this? Because we're not wading into foreign affairs. Congress did it, right? A majority of both houses of Congress voted on it. We're just looking at what Congress did. Why do we, as judges, have any competency to consider international law? I mean, I don't think we do.
Well, it's a question of checks and balances in this instance. I mean, right? As opposed to the opposition, what they're claiming is that Congress is a step above the president, and what they seem to be arguing is that Congress has the ability to tell the president what to do in this instance of foreign affairs. And it's a question of checks and balances. The Congress and the president and the courts, they're all equals, handling different areas of our government. And if the second we place one over the other, we violate that ability of checks and balances, and we violate the ability for the government to run itself effectively.
Okay, you can go ahead and continue with your argument.
Okay. These powers of the president have, over time, turned into the power of recognition. The power to recognize other foreign nations significantly alters a nation's relationship with the United States. The president has been able to recognize other nations by using his explicit power of receiving ambassadors. In this case, the president has decided not to recognize Jerusalem as part of Israel, and Congress's attempt to regulate this recognition power is an infringement on the executive's right to put Jerusalem on American passports. The power whether or not to recognize foreign countries can also be derived from the founder's statements and others concerning the framing of the Constitution, along with its intent in outlining presidential power. In Pacificus, Alexander Hamilton's pseudonym, also the same author of Federalist 69, clarified the executive's power in deciding foreign affairs when supporting George Washington's decision on neutrality with France during the French Revolution. He stated that the legislative department is not the organ of intercourse between the United States and foreign nations. It is charged neither with making nor interpreting treaties. It is therefore not naturally that organ of government with regard to foreign powers. Executive power of the nation is vested in the president, subject only to the exceptions and qualifications which are expressed within the instrument. Hamilton intended that foreign power be vested in the executive only. He states that Congress only has power over the government where explicitly stated. In non-explicit instances, the president has full power over the situation. The legislator is not naturally involved in foreign affairs, and therefore does not have the power to recognize Jerusalem or any other country. Congress's role, as outlined clearly in Article 1, includes approval for spending, consent for finalizing trade agreements, and certain war powers. None of these powers include or are meant to include recognizing foreign nations, and thus Congress has no right to force recognition of Jerusalem as being part of Israel. Thomas Jefferson adds to the idea that the executive was meant to hold recognition power when he describes his vision on the Senate's strict and limited roles in regards to respecting diplomatic appointments. He states that the transaction of foreign business with foreign nations is executive altogether. The Senate is not supposed by the Constitution to be acquainted with the concerns of the executive department. Exceptions are to be construed strictly. It is clear by his point of view that there was intended to be a firm separation of powers between Congress and the executive when it comes to international affairs. The recognition power, thus, is solely in the hands of the president, not jointly exercised between both branches. The United States' early political figures also touch on the importance of the executive's explicit receiving power, specifically when dealing with a country in political distress. St. George Tucker, a judge of the General Court of Virginia, stated that the president alone has power to receive foreign ministers, a power of some importance, as it may sometimes involve in the exercise of questions of delicacy, especially in recognition of authorities of a doubtful nature, such as what we are dealing with now.
Can I ask you a question? It's an interesting citation from Henry St. George Tucker, but he wasn't part of the drafting of the Constitution. So why should we listen to what he's saying?
I mean, just because you weren't a drafter of the Constitution doesn't mean that you had a voice in political early America. There were many, many people. There are many voices that are important, such as Joseph Story, who I was about to talk about as well, who were important. I mean, they served on the Supreme Court. They knew what they were doing, and they are part of our originalist text because they are a voice of early American government. And that is how we understand what was supposed to be.
But how is what Tucker is saying any different than if your colleagues on the other side, they're alleging something completely different. And they're basing their comments on both the text of the Constitution and subsequent history and government practice. Why should aside from it providing some useful information, why should we take that as legally relevant?
Well, he did serve on the Supreme Court in the 1700s, and thus he set precedent. A lot of what he did set precedent. A lot of what he did.
This is St. George Tucker.
Right. Court of Appeals. Sorry, Court of Appeals. And so a lot of what he did.
Well, he served on the. Didn't he serve on the Virginia Court of Appeals?
Yeah.
So that's the state of Virginia. So
right.
Do you think perhaps he's more familiar with Virginia constitutional law than federal constitutional law?
Well, I mean, he's an embodiment of the ideology at the time. These are political experts that we're talking about who knew the Constitution, who knew the people who drafted the Constitution. These are, if you went to a party with these people, they would all know each other. They would all be debating ideas.
But aren't these also political actors responding to particular political situations at the time? And isn't his interpretation perhaps influenced by his own political views?
I mean, not necessarily. And obviously, yes, could be biased, but also Alexander Hamilton, Thomas Jefferson, other drafters of the Constitution could be biased.
All drafters and also all political actors soon thereafter.
So let me, if I can elaborate on Justice Silverbrook's question. Why do we put so much weight on what we call originalism, right? Why do we put so much weight on the founding era when at bottom these were advocates? They were politicians who were advocating for a certain position, right? Why isn't the enterprise we put so much weight on this history?
Well, we need to look at other people who not only just drafted the Constitution, but also were just involved during that time, because the Constitution is ambiguous. There are so many things that we don't understand. That's why we are here today arguing this controversy, because it's so ambiguous. I mean, it's the same reason that religion, there are so many different religions, because we think of the Bible as ambiguous in itself. Every document, every important document, has to have some type of, there has to be, it's ambiguous. We don't necessarily know what they meant.
Sorry to interrupt you, Counselor, but let me put this point in even starker terms, okay? If the document itself is ambiguous, and in order to get to your argument that the recognition power is exclusive, you're relying on post-ratification commentary from people who are, at bottom, political actors. Is it really an exclusive authority that's set out in the text of the Constitution, or is this really a shared authority like your opposing counsel argues?
Well, we're not just relying on Joseph Story and George Tucker. We're also relying on big cases like Curtis Wright.
Okay, tell us about that.
He talked about...
well, it's setting a historical precedent for these cases. In the case of Curtis Wright, Congress in a joint resolution had given the president the option to place an embargo on nations located in South America that engaged in the Chaco War. The Curtis Wright Export Company sold fighter planes and bombers to Bolivia, which violated the embargo, and the company was then prosecuted. Basically, the defense argued that Congress had improperly delegated their authority of the embargo to the president, and therefore that the company hadn't violated an embargo because there was no embargo to violate. This court then declared that this was not the case, and that in the case of Justice Sullivan, he stated that the president is the sole organ of federal government, specifically a power which does not require an act of Congress. His statement there that the president is the sole organ of the federal government in the field of international relations, that is a statement that the president is independent of Congress. The court then declared, not just one justice, but the entire court then declared in their statement that there is sufficient warrant for the broad discretion vested in the president to determine whether the enforcement of the statute will have a beneficial effect upon the reestablishment of peace in the affected countries. This can also be interpreted as the president has a broad discretion to use his logic to say that this will have a positive effect or this will have a negative effect, therefore, and then the president has the ability to act on that. So in this case, because this case is so heavily debated and so controversial, basically what the court just said was the president has the ability to say this piece of legislation could be potentially damaging to our political litigation, our political stances, our political relations with these countries, and therefore it should not be a piece of litigation.
But let's get back to my previous question.
There's about 1 minute left.
Sorry, go ahead. You can finish up.
Sorry, I was saying, and the majority opinion actually describes that power as plenary. So, and we have 1 minute, you said? Mm-hmm. Okay. You want to,
I can.
Okay, I'll go. Joseph Story, an American jurist who served in the Supreme Court in the 18th century, stated, "The power to receive ambassadors and ministers is always an important and sometimes a very delicate function, since it constitutes the only accredited medium through which negotiations and friendly relations are ordinarily carried on with foreign powers." He adds that a delicate occasion is when a civil war breaks out within a nation and two nations are formed, each claiming the sovereignty of the whole, and the contest remains as yet undecided. In such a case, the neutral nation may very properly withhold its recognition of the supremacy power of either party. So as you can see here, it's an event. It's a situation that is very much like ours. We have Israel and Palestine both duking it out in one nation, both duking it out to see who holds the power of Jerusalem. And according to Joseph Story, an 18th century jurist, we should just remain neutral, much like George Washington remained neutral with the French Republic, in order to get rid of controversy, in order to avoid this whole huge political question and have to dive deep into foreign affairs with the United States.
And the congressional branch is not a united branch. Therefore, how can they provide a united front by which the U.S. can establish consistent foreign policy behind? Also, its consistency and its efficiency. The president is the sole representative of America as a political figure. He's a representative, and he can work efficiently. 535 members of Congress cannot work efficiently to pass litigation. That's why we have such an impasse in congressional branch. Is because there's no efficiency in that. Whereas the one man can make a declaration. We've seen it consistently through President Franklin D. Roosevelt using his recognition power to formally recognize the Soviet Union after 16 years of non-recognition. We've seen it through Israel. Truman recognized Israel using his sole delegation power, delegate power of recognition. It's been consistently used over and over and over again. It's a historical context that has been established consistently, and it's a matter of consistency just in terms of foreign relations, as the president is the sole figurehead of the United States when it comes to foreign relations.
And it's very different than the Youngstown case. Our petitioners talked about the Youngstown case. This is something. These are powers that are very, very obviously implied in the Constitution. This is not Taft and Teddy just going off on their own rant about imprisoning and sanctioning and everything like that. These are powers, yes, seizing steel company production. These are powers that are very obviously implied, and they're not coming out of nowhere. They, like he said, Roosevelt used it, Nixon used it to recognize China. James Monroe used it in order to give America a strong political stance internationally. This is a power that is not new, and it shouldn't be that controversial because it is so obviously implied within the Constitution. And Alexander Hamilton, Thomas Jefferson, Joseph Story, George Tucker, all of these people have talked about the executive power solely in international affairs.
Okay, thank you very much.
Councilor, your time is up. We have 5 minutes left for the rebuttal from the petitioners. Councilor, whenever you're ready.
Well, I'd first like to thank you for these next 5 minutes to rebut, and we're going to rebut first the two main arguments that we find key with our respondents' case. The first of that being that first, the power of recognition, specifically recognizing another nation and their government, is very obviously implied and delegated to the president in the Constitution. Then after that, the idea that the recognition power must be an exclusive power, and that we need to provide a united front for this power to be given. In that first part about it being very obviously implied, they stated that one of the last things they said during Youngstown, how these powers are implied and obvious and explicit in the Constitution. They relied very heavily on Article 2, Section 3, specifically ambassadors and treaties, as well as I'm guessing they had the idea of commander-in-chief in there.
However,
and we can find that those powers are all they're not exclusive. If you want to argue that it's an exclusive power and that it's very easily delegated and that leads to recognition in the Constitution, then you're making kind of a stretch because first off, your commander-in-chief and you've got to wait for Congress to declare war. If you're going to receive an ambassador, then you've got to wait for Congress to first open up ties with that nation. If you're going to make a treaty, then that treaty has to be approved by Congress. And that we know that this idea of checks and balances is so important to the founders and throughout the Constitution. So if you're going to argue first that recognition is implied and very expressly delegated to the president, first off, I mean, you can receive ambassadors without meant to be a ministerial duty because you receive ambassadors every single day of the week. It's just sort of something that happens that the president gets a person and then signs a piece of paper and now you're...
So is your argument that receiving ambassadors has no legal effect?
My argument isn't that receiving ambassadors has no legal effect, but my argument is that Congress wasn't given that power because you don't need 535 people there all year so that they can receive.
Well, I understand that, but my question's a little bit different than that, right? You're saying it's ministerial, ceremonial, we receive ambassadors every day. In receiving that ambassador, it doesn't have any legal significance about whether or not we're recognizing that ambassador as the person in control of the country they represent, or the person who's representing that country on behalf of the leader of the country who has authority over that sovereign territory. You see what I'm saying?
Well, I see that you're saying that recognizing ambassadors is important if you're, thawing ties or extending ties to another nation.
We agree.
We agree. We do agree with that. But the problem that we have with what the president, with this case and what the president is trying to do in this case, first off, we're not receiving ambassadors. We have already recognized this territory. And second off, once you receive ambassadors, it's usually one of the last parts of a much longer process. It's not usually just the ambassador shows up and the president decides by himself, I'm going to recognize this nation.
Okay, that's a more, that's good. That's a more nuanced, okay, so you're arguing that receiving ambassadors is not coextensive with the exclusive recognition power that your opposing counsel is arguing. Okay.
And as the exclusive power, that's the next thing that my opponent's argument hinges on, is that they're arguing that we need a singular voice and that Congress is not a singular voice, that Congress is very divided, and that when we're making foreign policy decisions, we need a singular voice to do that. And I mean, this is very flawed because when we're making foreign policy decisions, you can think of it almost like another legislative action. That's the country that needs to decide on what it's doing. And we can't have one person, one president who's elected every 4 years, and we happen to elect the other party in power every other 2 years. We can't put that much weight on him. We can't put that much power in his hands, and we give Congress the rest of the power. We give them domestic power, and we give them the power to make laws and to more or less set the rest of the agenda.
You have one minute left. Counsel, you have 1 minute left.
Additionally, I'd just like to, counsel brought up the case of Curtis Wright as in favor of their case, but we would also like to argue that this case doesn't necessarily refute our position. In the case of Curtis Wright, the situation was different. The president and Congress were on the same side, if you will. There was no opposition in that decision. And so we think that that doesn't necessarily dispute our argument in this case.
Okay, Counselor, anything else, Justice Silverbrook?
I have no further questions. Thank you.
Okay, well, we thank both of you, or actually all four of you, for your excellent arguments. You have no idea how proud we are of you to be engaging in such a high level of constitutional discourse. You are really a testament to education. We thank your teacher, and we thank everyone at your school for participating. And we will be in touch with you very shortly about advancing to the next round. Justice Silverbrook, do you have anything else to add?
No, I just want to say that all of you responded really well to what ended up being sort of a hot bench. I obviously asked a number of, I think, challenging questions, and I really wanted to tease out your conception of the constitutional division of authority between Congress and the executive. So I was maybe a little hard on you, but that was because I think you show a certain sophistication in what you're arguing, and so I just really wanted to push you to think about, and think about this after today too, think about the consequences of what you're arguing in this particular context in other contexts as well, right? So if you're enlarging the scope of congressional power, you enlarging it so much that you're essentially pushing the executive out of the equation, or vice versa if you're the executive. So think, think a little bit about that after this, particularly if you advanced on to the next round. But I congratulate you on a job well done, and especially responding so well to a fire alarm right in the middle of the beginning of your argument and some technological issues. So I thank you, and I just want to reiterate what Justice Blackmun said, which is that you really are a testament to the incredible young citizens in this country who take time to educate themselves about the Constitution. So we applaud you. And truthfully, we both do get kind of emotional about this kind of stuff. So we really are proud of you guys.
We were both almost crying this morning when we were judging your colleagues, so we're very proud. So thank you so much. All right, and with that, court is adjourned. Thank you so much.
Thank you.
Thank you.